Evening, everyone. My name is Barbara Graves-Poller. I am a member of the Women in the Courts Task Force here at the City Bar. I am not the public advocate of the City of New York. We will be expecting the public advocate to come shortly, and when she does, we'll break for her remarks because this is an issue of great importance to her and her office. So thank you for coming tonight. As I said, I'm Barbara Graves-Poller, and the Women in the Courts Task Force is happy to once again have our program, our annual program here at the City Bar about language access. In the interest of time, I want to just briefly introduce our panelists in alphabetical order, not necessarily the order that they're sitting in. And then as we go through the program tonight, I'll just ask them to describe their work in a little bit more detail in response to the questions that I'll pose, and then also questions from the audience. So first we have Sandra Bryan, who is the coordinator of court interpreting services at the Office of Court Administration. Belkis Garcia, who's a staff attorney in the Legal Aid Society's Civil Division. Amber Green is not here yet, but she will be here momentarily with the Public Advocate. She's the Director of Policy in the Office of the Public Advocate. Kavita Pawria-Sanchez, General Counsel in the Mayor's Office of Immigrant Affairs. Hannah Pennington, Executive Director of the Mayor's Office to Combat Domestic Violence, the New York City Family Justice Center, Manhattan, a long and very important name. And Amy Taylor, Senior Staff Attorney and Coordinator of the Equal Rights Initiative at Legal Services, NYC. So thank you all for being on our panel. Once again, we will leave a space for Amber Green to also join our panel shortly. Looking out into the audience, I see a number of people who've been here in our past programs and who for many years have been working on language access issues. But we also have a number of students and interested in community members who are new to these issues. So thank you, too, for joining us this evening. And this task force has principally focused on challenges and progress that we've made in the New York City courts with respect to interpreter services. We have a number of interpreters here with us tonight. And while courthouse interpretation remains a critical issue, we want to make sure that we will address in tonight's program. We thought that given the tremendous turnover in city agencies, and not to mention the mayor's office itself, that the time was right for us to look at language access from a broader perspective and explore ways in which language access policies outside of the courthouse impact New Yorkers who have limited English proficiency or are deaf and use sign language. And we want to make sure that we are looking at the issues that these New Yorkers face before they even get to the courthouse and need a courthouse interpreter. It would be absolutely impossible for us to try and address the language access policies at all of this city's agencies and many of the other institutions throughout the city that are subject to federal, state, and local language access mandates. But with that in mind, we're going to structure tonight's conversation around some agencies that are of great importance, particularly to low-income New Yorkers that rely on legal aid services, and also that have come up in our past programs about the courts. So first, we're going to talk about the Human Resources Administration, that we'll refer to as also HRA, the New York Police Department, the courts, and the Board of Elections. And I hope that our panelists and members of the audience will feel free to bring up issues at other agencies based on their own experience. So there are a number of federal, state, and local laws regarding access to public services for persons with limited English proficiency and also deaf persons. So to make sure that we're all starting from a similar point of understanding, I'd like to start by asking Kavita, what is Executive Order 120? And what role does the Mayor's Office for Immigrant Affairs play in ensuring its enforcement?
Sure. So in many ways, I feel like I'm speaking to a room full of people who are very familiar with Executive Order 120, but I'll lay out the basics anyway and maybe focus a little bit more on enforcement and what our office, as well as other city agencies, are doing around enforcing and making sure that there's real meaning to Executive Order 120 beyond the weight of the paper it's on. So Executive Order 120 is a language access policy that is citywide. It was signed by Mayor Bloomberg in 2008 and impacts all city agencies that provide direct services to the public. It lays out a number of requirements. I won't go into all of them, but the basic gist of them being that all city agencies providing direct public services should be providing interpretation, so verbal interpretation or oral interpretation, and they should be translating their essential public documents into the top 6 languages. The top 6 languages spoken in New York City, with some discretion. So agencies have some discretion to decide or to look at those languages and think about how they apply to their populations. But for the most part, most agencies translate into the top 6, which are, or were at the time, Spanish, Haitian Creole, Russian, Chinese, Korean, and the executive order names Italian, but many agencies actually do Arabic. The executive order also, for the first time, required agencies to name a language access coordinator, so someone charged with overseeing and looking at how language services were being implemented at their agency. It required agencies to develop a plan around providing language services and to implement that plan, to monitor that plan, and to post signage in conspicuous locations informing the public that language services are available. So that executive order is now almost 6 years old. It's about 5.5 years old. It was signed in the summer of 2008, I think, if I remember that correctly. And there's been a lot of questions around what the meaning of executive orders from the prior administration are. We are treating that one as continuous, as standing, unless someone else says otherwise. We continue to treat EO 120 with seriousness, and in fact, I think a new level of seriousness and commitment. So this administration is very, very committed to language access, and I'm terribly excited about that. I think there's a lot of possibilities for the future that to build on the foundation of the last administration, which also took it very seriously. But if you depending on how much attention you were paying to Mayor de Blasio's campaign, language access was mentioned quite a bit. It is in his campaign, his official campaign document, and since he became mayor, it is something that's been talked about quite a bit, at least in my world. So we're really glad to see that.
Kavita, if I can just interrupt for
Sure.
1 second. I think all of us heard candidate de Blasio talking a lot about language access and general equality for all of New York City's communities. But I'm interested in focusing a little bit also on ways to really enforce language access and monitor it now under the new administration. And so going back to the prior administration, back in December 2011, your office released a white paper that outlined a number of short-term and long-term goals for sharing best practices, improving language services, and setting goals with respect to language access at city agencies. And among them was the requirement that language access indicators be included in the mayor's management report. Understanding that we're still in a time of transition, but the February 2014 preliminary mayor's management report did not address these issues. So I'm wondering how the de Blasio administration will either move forward with this recommendation or come up with an alternative strategy.
Sure. So actually, I think that in the world of language access, if we look at the long view of it, that there's really a process, right? And in terms of getting to a perfect place, we aren't at a perfect place, but there's been a lot of foundational work done. And I think really upping the ante on the enforcement side, the monitoring and oversight side, and having real accountability is where we want to go next. And this administration is very committed to that, and it's something that my office is looking very closely at, along with the mayor's office of operations, because we're both charged with overseeing the implementation of this policy, and we know that there's work to do. In terms of the MMR, so the MMR, for folks who don't know, is the mayor's management report, and I don't know the full history of it, but it was It was started many years ago to provide transparency in government and to essentially share data with the public around how agencies were performing. A few years ago, a language access indicator was added to the MMR, and that indicator says one very simple thing about several agencies, and that's how many requests for interpretation each agency has received. So that indicator is included in the MMR every year. The February version is the preliminary MMR, and I believe in order to reduce the burden of data reporting on agencies, they're only required to report on it at the end of every fiscal year, so it shows up in the September MMR, but it does not show up in the mid-year preliminary. But it's something, we're willing to look at if folks feel like that's an important indicator that you want to see more often. And in general, we are looking at the MMR in terms of how we might use that tool and others to measure progress more seriously, more meaningfully in terms of A, language access, and B, in terms of immigrant access overall, kind of moving at 50,000 feet in this conversation.
So maybe it would be good to look more specifically at our focused agencies now and think more about how both through the complaint processes and other issues that our panelists and audience members raise, how we might feed into the analysis that your office is doing. Belkis, around the same time that the Mayor's Office for Immigrant Affairs convened its Language Access Symposium in 2011, the Legal Aid Society provided City Council testimony on the lack of language access services at local Human Resources Administration offices. So for those in the audience who might not be familiar with that testimony, can you describe first some of the services that your clients seek from HRA, and then talk about the observations made then and whether those still seem to be accurate today?
Sure. So can people hear me okay? No. No. What do I do?
It looks on. You might just need to speak up a little.
I'm going to switch these.
Let me take this one.
Mine's going to be blue.
Okay. How's that? Good. Okay. So I work at the Legal Aid Society, and from 2007 through 2011, I worked in the Bronx neighborhood office doing government benefits work, which means I was assisting people with public assistance. As you may know, the Bronx is one of the poorest counties in the nation. My clients were overwhelmingly very low income, generally had very low education levels, very low job history and job skills. Many are survivors of violence. Many people are struggling with physical and mental disabilities. So these are people who rely very heavily on the government benefit system. So I think language access is, and vast majority of my clients were also limited English proficient. So there's a series of barriers working against people at one time, language access being one of them, but it's a complicated set of circumstances. So I'd like to just give some context and explain what HRA is and what they do. So and what it means to live inside the public assistance system. So the Human Resources Administration is the city agency that administers public assistance, which is like cash benefits, food stamps, and Medicaid. I think it's worth saying that to have an open public assistance case, to both apply for public assistance and then to keep that case open, it's a full-time job. You are required to work 35 hours a week in order to get your benefits. If you can't work, then you have to do these other appointments and other programs. But it's a lot of work to keep your public assistance case open, and it involves a lot of appointments at the city agency, at HRA, for public assistance recipients in particular. So there's a lot of interaction with that agency for those folks, which means that there's a lot of opportunity to get it right, but there's also a lot of opportunity for mistakes. Do you want me to hold?
Sure. But I think that's also a good place to stop,
Okay.
because we now have a background on HRA,
Okay.
and we can pause and come back. as well, you just saw, the public advocate, Letitia James, has just come. And as you know, ensuring language access is not only a major issue for the mayor's office, but it's also been something that's been a feature of the public advocate's agenda as well. So we'd like to invite her to speak for a few minutes about how ensuring meaningful access to city agencies fits into her agenda, and then we'll come back to the discussion about HRA and then go into the NYPD.
Good evening, everyone. First, let me recognize my friend, my sister, my colleague in city government, Councilmember Rosie Mendez, who's an attorney in her own right and a fabulous woman in the city council. And she is the chair of the Black, Puerto Rican, and Asian Caucus. Rosie, come on up. Councilmember, you're good? Okay. She's good. She doesn't usually lead from the back, but I'll give her an out today. So first, good evening, everyone. It's a pleasure to be here with you tonight. Thank you to the New York City Bar Association for the invitation. As some of you may know, before taking office, I practiced law for many years, and from time to time, I tend to practice it. Normally, it usually happens like this. My neighbors knock on my door, and they say, Tish, one of my children, unfortunately, have been incarcerated this evening, and I need you to accompany me down into criminal court. That's usually how it works, and oftentimes I volunteer and offer my services pro bono to countless number of individuals in the criminal justice system. As a former legal aid attorney and as a former assistant attorney general, I always put those skills to good use. So it's wonderful to see some familiar faces in the audience and be amongst friends and former colleagues to discuss such an important issue. And also, let me add that Rosie was also a former legal aid attorney, which is why she and I are so close. As recently as two legal services, legal aid, pro bono attorneys. So as recently as 2008, 1 in 4 New Yorkers did not speak English at his or her as their primary language. Non-English speakers contribute to the New York City community in every way, economically, culturally, socially. They are our friends, our neighbors, and our colleagues. The diversity of our city is one thing that makes it so special. But with such diversity comes great responsibility. It is my job as the public advocate to ensure that those with limited English proficiency are able to access and understand important services regarding their housing, employment, health care, and the like. This is not only a matter of common sense, but also an issue of great legal import. Every New Yorker, no matter what language they speak, should be able to access and fully benefit from government's services. Daisy Garcia certainly should have been able to. Daisy was a 21-year-old mother of 2 living in Queens. She filled out a domestic violence report in her native language, Spanish, after being violently assaulted by her husband. In the report, she wrote that she was afraid of her husband, and she was afraid that he was going to kill her and her small children. Well, that's exactly what he did. Why? Perhaps in part because that domestic violence report was never translated by NYPD into English. They never bothered to even translate it. And perhaps her children would not have been in this position, but for the fact that they failed to ignore, they ignored the law. And for that matter, the second report that she filled out 6 months later was also ignored. I've been following Daisy's case closely, and hope that there is justice for her and her 2 little girls. One way I'm going to ensure that is by working to improve translation services at all government agencies in the city of New York. And let me also recognize Shamtoli Haq, who is the lead attorney in my office, who is assisting us in this effort, as well as Amber Green, who's head of the policy unit, who's on the panel this evening. But the government agencies not only include NYPD, they also include the Board of Elections. Recently it was brought to my attention that voter registration materials in Bengali and Korean have not been accurately translated, and that those voter materials contain numerous errors that could result in the denial of the right to vote in those language communities. I was also told most recently that during my last election that my name was unfortunately not translated properly. Similarly, my office has received complaints that there's a lack of both Spanish and sign language interpreters at certain polling places. There is simply nothing more important in a democratic society than equal access to the ballot box, and I have reached out to the Commissioner of the Board of Elections to request that these problems be addressed and be remedied immediately. Executive Order 120 was implemented in 2008 in order to ensure that all city agencies that take steps necessarily to effectively serve non-English speakers. While some progress has been made, many agencies are still failing to provide adequate language assistance to limited English proficiency New Yorkers. According to research by the New York Immigration Coalition and Make the Road New York, between 2009 and 2010, HRA failed to provide language assistance to 44% of those surveyed. NYPD failed to provide services to 67% of those surveyed. HPD failed to provide services to 61% of those surveyed. Many respondents were unaware that language services were even available. I don't know about you, but this is simply unacceptable. And my office is working to change that. We are attacking the problem from several different angles: legislation, oversight, investigation, and compliance. And I hope that all of you in this room would join with me in this effort to ensure that there is compliance with the law. Let me just do a commercial at this point in time. We're looking for volunteers. So any of you who are available who would like to add your assistance, add your expertise to the Office of Public Advocate, please see Amber Green. Again, I'd like to work both with other advocates and partners to put together a report on agency compliance with Executive Order 120, as well as hold a hearing on the matter. So if you or your clients have a problem with a particular agency, please contact my office and let us know. I can't fix it if I don't know anything about it. Democracy is not a spectator sport. It requires the participation of everyone. And I need, obviously, to ensure that there is compliance with this law if we are to avoid any more incidents from happening, any more homicides from happening. If we can save another person's life, someone who's been a victim of domestic violence. I look forward to hearing your suggestions as to how we can work together to effect meaningful change and ensure that non-English speaking New Yorkers have access to agency services. Let me close on a note today. I went on a tour of a school in Queens. I went on a tour because I heard that one school in particular had 23 trailers where children were being taught. The trailers were named the International Academy because all of the children in these trailers were English language learners. And when I visited, it was true. All of the trailers were packed. All of the children were English language learners. It was basically a United Nations, a public school. As an aside, it's a public school which is slated for co-location, but that's another discussion. My point is that there were a number of individuals and parents who were just totally unaware of their rights, unaware of their right to protest, unaware of their right to call the conditions that I witnessed into question. And I just know that we can do better in New York City, and I hope to join with you to improve the conditions of those who have come to these shores for a better life. Thank you.
So I'd like to thank the public advocate again for coming and sharing both her agenda and the work that, and asking for volunteers from all of us here. But I want to go back to that 44%. We were talking about HRA and the fact that we've now just heard that 44% of the people who are seeking assistance from HRA with respect to language access did not get it. Bilkis, practically speaking, what did that mean for your clients and the clients that come to your practice?
Yeah, that's not at all surprising to me to hear that statistic. I didn't know it. So yeah, I can say, I mean, I should also, I kind of want to preface that the appointments at the center are, you know, while I'm sure there are really wonderful people that work there and helpful people, by and large our clients report a very negative experience at the centers. I mean, the descriptions, they range from like unpleasant to dehumanizing, and in that context, it's very hard for somebody to assert their rights, and it's that much harder if you're not actually able to get somebody who you can literally communicate with.
Maybe if we can pause for a second, because I see Amy nodding her head, and I know that these are issues that I assume were at the core of the pawria litigation. I hope I'm not mispronouncing it.
Yeah.
Can you talk a little bit about how you worked with your clients to try to address these HRA issues through litigation?
Sure. Barbara was referencing the pawria litigation, which we filed in 2009. And this was really after years of our advocates reporting from around the city that clients applying for benefits at HRA were being routinely turned away, being told you need to speak English, being told come back with someone who speaks English. And we, over the years, did a lot of advocacy, and with Bilkis, we did this together as well, sending clients to HRA with a letter that outlined what the law was, what the agency was required to do, and still being told you need to come back with someone who speaks English. And I think it's just really important to recognize oftentimes language access is framed as the right to an interpreter, which it is, but it's really the right to access the underlying benefit. And so for our clients, being told, come back with someone who speaks English, for many of them that meant not being able to access their food stamps, not being able to enroll their child in Medicaid. We had one of our plaintiffs in the lawsuit had gone to HRA 9 times to enroll her children on public assistance, and each time was turned away. And I have to report that she presently, today, is still denied an interpreter every time she goes to HRA. So, you know, we're so excited to hear that this issue is finally being taken seriously by the new administration, and we really hope that, you know, the policies on paper which exist, and, you know, at HRA and at many agencies, there are many, many written procedures about what should happen at the agency, but very few systems in place to actually make sure that those services are provided. So, you know, at all points of contact, from application, notices being sent in the appropriate language. As Bilkis mentioned, once you are able to even enroll in the benefit, you have to do hundreds of things to stay on those benefits. So when you get a notice in the mail, it's really important that clients are able to understand that notice and to know that they have an appointment that they must attend. So we see problems across the board, and we filed the litigation on behalf of 8 individuals, and then also a community-based organization that represents hundreds of individuals facing the same barriers.
And Amy, we're going to come back to another case of yours in a minute, and let's turn this discussion to NYPD, because the other case we're going to talk about, the Padilla-Torres case, addresses that agency. But before we get to that, Hannah, can you talk a little bit about the work that the Mayor's Office to Combat Domestic Violence does and how its partnerships are structured?
Certainly. So actually I see a lot of familiar faces. So like Kavita, I feel like I'm talking to an audience that's very, very familiar with the issues we're dealing with today. And I am the executive director of the Manhattan Family Justice Center, which just opened a couple weeks ago, and of course the Family Justice Centers, which are now in 4 boroughs, and there's one coming to Staten Island by the end of this year or the beginning of next, are the biggest project of the Mayor's Office to Combat Domestic Violence. So I'm really excited to be here because the Mayor's Office to Combat Domestic Violence primary mission of the office is access to services, and so of course language access is the most important part of that. So it's very exciting to be here. Also with Councilmember Mendez, although did she leave because I'm a Rutgers grad? Oh, there you are. So I'm excited for that reason too. I think what I wanted to start with is to talk about sort of a lot of the outreach efforts of our office, because I think outreach, and especially a lot of enhanced outreach that we're going to be working on with our new commissioner, Rose Pierre-Louis, who has done the work that you all do in practice, so she knows how important this is too, is such an important part of language access, because Daisy Garcia being a good example, people knowing, survivors of domestic violence, sexual assault, elder abuse, trafficking, all of which is what we deal with at the Family Justice Centers. The barriers that exist are tremendous when you don't even throw in all the other barriers that are surround language access and other issues of poverty, et cetera. So being able to get the message out that help is available, but then doing that in a way that makes that actually known to people who don't speak English is the most important thing that we can do. So to your theme of sort of the new day and what are we doing, that's a huge part of what we're doing. I personally have been spending a lot of time outside of the 9 to 5 walk-in hours of our Family Justice Center, out in the community in Manhattan and other boroughs, making sure, and I hope that you'll all continue in doing what you're doing to get the word out. But that the Family Justice Centers, which I know a lot of you are familiar with, but just to talk very briefly for those of you who are not, again, I would say it's pretty easy to talk about language access because the entire mission of the Family Justice Center is to put all of the services that are needed for survivors of intimate partner violence and all of the other things that I mentioned in one location. And they're walk-in centers, which is actually an unusual feature of a victim service agency because normally there are real safety concerns and confidentiality issues around those locations. So since we are co-located with district attorney's office and city-owned buildings that are highly secure, we're able to offer these services as a walk-in service. But for that reason, the most important thing we need to do is to make sure that when like I said, out in the community, that people know that those services are available, but when they come, that we have a language access plan that makes that work for the clients who are coming to us. So we do a lot of different things to make sure that that works. I wanted to recognize my colleague, Sarah Flato, who is here. She's our Director of Outreach and Programs at my center in Manhattan. She comes to us from the Mayor's Office on Immigrant Affairs, so I snatched her up quickly because she is a real expert, and she is our point person at the Manhattan Family Justice Center on language access. And of course, we're only a few weeks old, but I speak collectively because, like I said, there's now a center in Brooklyn, Bronx, Queens, and Manhattan. And we have a multilingual staff at all the centers collectively. The staff speak over 25 languages, but then importantly, we have language line on every single phone in every single Family Justice Center. So within seconds, you have access to over 200 languages, which is important. But then in order for that all to work, training, cross-training. So training of the staff that are on-site partners, some of who are here today, our off-site partners who are sending the clients to us so they have an understanding of how things work and they can prepare clients when they're not walk-in clients, but there's an appointment, and training everyone. This is something we actually have done in Manhattan that we're very excited about. I have a great partnership with the District Attorney's Office, which is where we're co-located. And Audrey Moore, who's the chief of the Special Victims Bureau, and I have talked a lot about these issues. And, you know, of course, the people who are coming to our center have been coming to 80 Center Street, which is where we're located, for a long time. And they've been going through these processes in different ways before we came along. But there's, again, a new day, a new opportunity. So we spent a lot of time in January training all of the staff at 80 Center Street, the building staff, the security staff, to make sure that the first point of contact. So our signage is not completely right yet because we're only 2 weeks old. So it's coming on the first floor. Up on the 5th floor we're located, it is. But to be able to have the security staff not only be prepared to have an understanding of what a domestic survivor may have going on in their lives when they first come, but then also having them have an understanding for limited English proficient folks. So I think that starts to answer your question, right?
It does, and I think it would also be useful to maybe go to Amy to talk a little bit about how, first of all, that was a great overview of the Family Justice Center, and we've been talking in sort of broad terms about language access. But Amy, can you explain the difference between interpretation, translation, and then how those issues played out in your in the Padilla-Torres litigation?
Sure. Again, I don't think this crowd probably needs the clarification, but translation is the conversion of written text from one language to another, and interpretation is the conversion of speech from one language to another. And both of those issues are relevant to our lawsuit right now that we're currently litigating against the NYPD. And this lawsuit arose out of our experience, and I will recognize my two colleagues who are involved in the lawsuit, Audrey Carr and Lori Izutsu, who are both here. But this lawsuit arose out of our experience at Legal Services working with survivors of domestic violence and crime victims who seek to access police services, and because they are limited English proficient, are denied interpreters and translation services and are unable to access those services. So for our clients, that means people who are unable to file a domestic incident report against an abuser, who are unable to seek protection from the police, and who are often discriminated against, humiliated, and in the case of two of our plaintiffs, arrested themselves when their abusers were not. Because what happens, and we see this routinely, is that the individual will call 911, and the 911 call system is actually very good at providing an interpreter. So they will get an interpreter when they call 911. They will say, that they need assistance, and when the police show up to the scene, they will be unable to communicate with the victim and will deny them the opportunity very often to file a police report. And these individuals are unable to seek protection. They're unable to get any help at all. And this happens when our clients try to follow up at police precincts as well. And in the case of two of our plaintiffs, the police officers arrived at the scene. The abusers both spoke English in these cases. In one case, the abuser accused the victim of abusing him, and he filed a report against her. She was begging and pleading in Spanish. Also, we have 2 million Spanish speakers in New York City, so it's really shocking. And no one ever took a statement from her. No one ever allowed her to file a complaint. She was arrested. She spent the night in jail with injuries. Another one of our plaintiffs was, when the police officers arrived, she was face down on a staircase after being pushed down by her husband. He was holding her by the leg, and she was never asked by the police officer what happened. She was visibly injured and very upset, and ended up being arrested herself as well. So these, the consequences are incredibly severe. And while our lawsuit primarily addresses the lack of oral interpretation provided by the NYPD, there are also relevant issues related to translation. As the public advocate mentioned in the case of Daisy Garcia, her statement was never translated at all. And that's very unsurprising to us. We see this happen quite a bit. On the domestic incident report, there's actually a space where victims are supposed to be provided with the opportunity to write a statement in any language. And many of our clients are never told that they can write a statement in their own language. Many clients are never told they can file a complaint at all. And for our clients who are able to write a statement in their own language, there's a second step that's very important, which is that the NYPD, when they enter the domestic incident report into their computer system, they have to translate that statement. And that's what didn't happen in the case of Daisy Garcia. And we see quite often when we get these reports back, through discovery or when we're representing a client in an order of protection case, that in the space where the statement goes, it will sometimes say Spanish with no statement at all, or and we've seen this a number of times, it will say uncooperative witness or refused. So here is someone who's limited English proficient attempting to make a statement in their own language, and they're being characterized as an uncooperative witness, which can obviously have really severe consequences for them if they're trying to get an order of protection, their credibility is at stake. So these are really, they're life and death situations, and it's just all too common.
So I hate to shift even away from this really important topic that you're addressing and also the public advocate addressed, but I want to also make sure that we start to talk about these same issues of interpreting and translation as they play out in the courts. For years, the Women in the Courts Task Force has organized this panel around how interpreters ensure access during courtroom proceedings. But as tonight's panelists and the public advocate have already shown, a lack of access outside of the courtroom can prevent someone from protecting the rights that they have when they're in the courtroom. And so just focusing on the courthouse areas outside of the courtroom itself, I want to turn to Sandra and ask a few questions. First, are pro se litigants who have limited English proficiency entitled to interpreter services in the clerk's office, which is a space in the courthouse but outside of the courtroom itself?
Sorry, can you hear me? I can talk louder.
Okay. Although actually, since it's being recorded, we may need to just...
Okay. Yes, absolutely. Absolutely. Yes, litigants, parties, anyone who walks through the door who requires an interpreter, upon request, the courts are obligated to provide them with the appropriate interpreter. Absolutely. And we have a number of languages on staff. And their responsibility is, of course, first of all, to be available to the courts and the proceedings inside the courtrooms before the judges. But if there is someone at a front counter, at the record room window, wherever they may be in the courthouse, yes, they would have to probably wait a couple of minutes or so, maybe from the morning into the afternoon, but they would be provided with an interpreter.
And so just to explore that a little more, I know when we were doing outreach for tonight's program, a number of advocates who practice in housing court raised the question of hallway negotiations.
Right.
If a pro se litigant in housing court is negotiating, let's just assume it's going to be a tenant, is negotiating with, say, a landlord's attorney out in the hallway, is that person entitled to an interpreter?
Well, again, if the party has requested an interpreter from the court, I can't see why they would be denied an interpreter. Normally, a court would not schedule an interpreter or assign an interpreter just for a negotiation in the hallway. It would have to be because they were in the courthouse for a court proceeding, and then the attorney may want to explain something in the hallway, and that's routinely done before the proceeding is held in the courtroom or afterwards as well. But they would be provided with one, but they have to make the request.
So someone would have to be before the judge first and then ask for an interpreter?
Well, the proceeding would have to be in the court for some reason, and not necessarily in front of the judge, but maybe it's a conference or something of that nature. But the courts generally, what we do is we look for an interpreter when there is a proceeding, a court proceeding. So a negotiation per se that's not going to be a court proceeding that day, it wouldn't trigger us finding an interpreter. But I'm very happy, if I could just say, to hear about the work that the administration is doing, because it occurs to me that an immigrant or someone who is not proficient in English, living in the community, chances are that if they have to come into the courts, they may have already dealt with another governmental agency, and I'm not too sure whether they would make the fine distinction to know that they would be entitled to a free interpreter in the courts if they've already gone to certain governmental agencies and been denied one. It's something that we're very comfortable and familiar with and know the difference between a city agency, a state agency, a court, which is a judicial branch of government. But I'm very happy to know that, because the more the word is out there that people are entitled to speak in the language they are most comfortable in, the more I think that they will demand this service, which they're entitled to in the courts as well.
And so just to close the loop on these other areas within the courthouse, you've been talking a lot about interpreter services in the clerk's offices, or maybe even in other negotiations just outside of the courtroom. But what about translation of written orders? Are pro se litigants in particular who might have a family court order, order of protection, or any other document that is any order from a judge, are they entitled to have that translated?
We do not translate orders. When someone is granted an order of protection, generally, whether it's in criminal court or in family court, the explanation of what is in the order and what the order contains is done usually in the court by the judge in English, and the interpreter who is assigned gives an oral on-site translation of what's contained in the order. But to this point, we have not officially translated orders. But we are looking into it, as a matter of fact. We have a pilot that we are going to roll out probably before the summer with a bilingual order. We've translated the bilingual order of protection used in family court and the temporary one as well. And that is something that we're going to see what the impact is in terms of internally for the organization and maintaining the statistics, and also how it helps the public as well.
That's a really exciting project. And, you know, Sandra, your office does fantastic work. So I feel a little guilty asking you some tough questions.
Go ahead.
But I do want to ask about the extent to which your office is involved in training new judges on language access and on how to work with interpreters. Because, you know, we did a fair amount of outreach before tonight's program with advocates and community organizations. And while interpreter issues do come up and are a matter of concern, we received a number of questions about judges, or a number of comments about judges who themselves are obstacles to litigants who are seeking to access interpreter services. So the short question is your office involved in training judges, and can you talk a little bit about that?
Yes, our office is involved. We yearly present in the Judicial Institute, which is really the place where the judicial training lives in White Plains. But our training with the judges covers things such as understanding that many legal terms and things like the order of protection do not exist in foreign languages, so you should expect interpreters to advise the court that this is a term that does not exist in a couple of different languages, and therefore judges will be asked to provide the explanation, which should be interpreted by the interpreter. We cover things related to language specifically. We explain that it is not something that is done word for word, and so you should expect, depending on the language, it may take less time to interpret a message, or at least 1/3 or maybe twice as long to interpret a message, and it doesn't mean that the interpreter is having a conversation. We cover things like ethics, and also skills that they should expect each interpreter to be able to provide in the courtroom. The 3 modes of interpretation. I know I don't want to get too technical here, but the parameters of the court interpreting job. And also, we let them know that they can also contact us if they have any question or any concern. We have an internal application that is available to judges right from their laptops throughout the state, where they can contact us if they have a complaint, a concern, a question about whether or not the interpreter seemed to be doing the right thing or the wrong thing, and we would follow up on that as well.
Do you know of any tools that exist at OCA for litigants who need to report actions taken by a particular judge that might have prevented their access to an interpreter? So, for example, we received comments from probably some people who are here, and certainly people I've talked to in the community, about judges who might begin a proceeding without waiting for an interpreter to arrive, or a judge who might hear a litigant speak a few words of English and then say that the litigant didn't need an interpreter. Do you know of any ways that someone can report that?
That can be reported to the administrative judge. They're all posted online. An individual could go to the chief clerk's office of that particular courthouse and ask who the administrative judge, and also, complain there. We've received a couple of emails in our office, not complaints about judges, but in foreign languages sometimes. So I guess, it's possible that someone could send a message in Spanish or one of our top languages where we have an interpreter on staff, and we'd get that translated as well. But really, I think for a judge, a complaint for a judge should be handled by the administrative judge, and I believe there's also a body, a judiciary body that someone should contact. But that information would be relayed to them by the chief clerk in the particular courthouse or the administrative judge. It's not something that our office handles, but that would be the way to report it.
Okay, and shifting gears a little bit more, and I won't ask you any more tough questions about judges.
Okay.
Amber, I just wanted to give you an opportunity to talk a little bit about some of the complaints that your office is receiving from constituents on the issues that we've addressed so far, and then discuss how you've been handling them.
Sure, thank you. Thanks everyone for having our office here to participate. In terms of complaints that we've received, the public advocate mentioned just a few. Actually, and that's the truth. We've only received quite a few from constituents directly. We've heard a lot from advocacy organizations, and one of the things that we wanted to change is that we do want to hear directly from constituents, to put a face to those stories, to be able to help them navigate their experiences with those city agencies. So we do look forward to working with each and every person and organization here to find out where those complaints may actually be. Additionally, we want to make sure that we are more accessible, so that we are making sure that we have enough people on staff that can help to address those complaints. We do have a robust constituent services unit. We're looking to expand that. We do have a number of volunteers that do help with that. We are a small office, as most people know. But we do want to make sure that we're hearing those complaints so that we can properly address them. Advocacy organizations have been very good at bringing those matters to us. So, for instance, we were able to find out that the Department of Homeless Services PATH Center actually was not set up to help those that were victims of domestic violence and sexual assault. And oftentimes, those victims would have to explain their story in front of their children because they don't have proper, partitions. But also the children we use to be able to, as interpreters, as translators. And that should never, ever be the case, especially for a person that's been a victim of sexual assault or domestic violence. So that's something that we'll be working with the administration to hopefully initiate some changes. And as the public advocate mentioned, our office is there to help. We're not here to demonize employees. We realize that all employees are doing their job. We want to make sure that if they don't have the resources, that they get those resources, and we advocate for the needs and for the changes of those matters. So as I mentioned, we do have some complaints, but I know, according to the statistics, 46% and upwards of individuals not being serviced at those agencies. We do want to know about that and hope that everybody will consider reaching out to our office as well as a resource.
We've been talking a lot so far about spoken languages and the most commonly spoken languages. We haven't talked as much about some of the less common languages, but I want to turn to Kavita and Hannah to talk a little bit about the ways that city agencies are facilitating access to services for deaf New Yorkers who rely on sign language interpreting. Kavita, how does your office work on this issue? And Hannah, can you talk a little bit about the approach in your office as well?
This was working. Mine's working.
This is working.
Oh, this now. I think this is.
Oh, that's the
yeah.
one.
I'm gonna put this away.
Sure. So I should put out a caveat, which is that our office is actually not the expert on these issues. And I think in retrospect, we would have had the mayor's office for people with disabilities here. So there is a special mayor's office that's dedicated to these issues, and I did get a chance to touch base with them before I came here. And they are very open to speaking with folks here that are interested in doing that as a follow-up. But I will say we have worked with the mayor's office for people with disabilities, both formally and informally. So informally, constituent cases come to the mayor's attention. People reach out to one of those mayor's offices, and we work together to make sure that an appropriate layered services are in place. And then formally, the mayor's office for people with disabilities has a regular body that convenes of ADA coordinators from all of the city agencies, and I actually represent Moya on that convening. And I think there's room there's a lot of work has started to happen in terms of interagency coordination in the city, and I think there's places to go with it, and our office is committed to working on those intersections in a deeper way, and want to hear more from you in particular around what those needs look like and how the city might fill those needs.
Now is mine working again? Yes, okay, good. So I can speak to, so before I took this job with the mayor's office, I actually worked as the legal director for Sanctuary for Families at the Bronx Family Justice Center full-time. So I had experience with serving deaf clients at that FJC, but also have worked with staff to prepare for this piece of our work at the Manhattan Family Justice Center. As a walk-in center, we need to be prepared for clients to come, again, because we want to make sure that we're providing access to all clients regardless of their needs. In Manhattan, we had created an arrangement with All Hands in Motion, which I'm sure a lot of people in the audience are familiar with, an expert consultant-based interpretation service company that we will have sort of on call. So we are exploring different things at the moment, but one thing is to make sure that they're on call so that if we can immediately get an interpreter, either an ASL interpreter, excuse me, or a certified deaf interpreter, will do so as quickly as possible, possibly sometimes getting assistance from the district attorney's office as well. But if we need to make an appointment the next day, we'll do that. That's often how it worked out in the Bronx, because similarly, they had an agency that they worked with very closely. But one thing we are exploring is at our reception desk and staff is to have a video chat option so that initial interaction, we can make sure that we're doing all that we can in the moment. And again, it goes, I think I mentioned earlier too, in terms of training. I think we also want to make sure as we're moving forward that we're doing ongoing training with staff at all levels around making sure that everybody is on the same page and making sure these services are available and done in the correct way. Like I said, front line downstairs or front line upstairs. And we're also excited to learn from our partners. I know that right now the DA's office and several of our on-site and off-site partners at the Manhattan Family Justice Center are working on a federal grant around these issues, sort of acknowledging because I'm talking a lot about barriers, but additional barriers in the population of survivors of domestic violence or sexual assault who are deaf, and recognizing the gaps in services in that particular area, some of which are unique, like, and this came up in the Bronx too, sort of confidentiality issues around interpreters in that community who a lot of people know people. There's just so many sensitive issues in the work that we're doing, so addressing that. CVTC and Connect, barrier-free living, and like I said, the District Attorney's Office, Harlem Independent Living Center, which is one of our off-site partners, are working to sort of assess those needs right now. So as going forward, we're going to be the beneficiaries of that because they're actually on-site at our center, and we'll be hosting meetings, et cetera. So that's just something to look forward to.
One issue that often comes up for individuals who rely on either sign language interpreter, actually, let's keep it on the in spoken language for a second, who rely on interpreter services, is that they may have difficulty understanding the substantive issues at stake for reasons that are separate from their English proficiency. And so I want to kind of go down the line and talk to panelists, starting with Sandra. To what extent are interpreters required to ensure that a litigant actually understands legal issues in their native language? And in fact, Hannah, when we get to you, you can also talk about it with respect to sign language interpreting as well.
I hope this doesn't shock anyone, but the extent is zero. And by what I mean by that is the court interpreters are really not to be the source of any information. They're the conduit of information. So let's say it's the court's responsibility to make sure, to have the interest and understand and make sure that someone understands it. We go through in detail in training and constant communication with the area supervisors around the state to reinforce this issue that the interpreters are not to change or edit the original message in any way whatsoever. So, and that goes both ways. So if an attorney or a judge is speaking in such a way that is too formal or too erudite or complicated for the litigant or the party who's being spoken to can understand it, that is not something that the interpreter should get involved with. The interpreter is supposed to take that message and convey it exactly the same, in the same formal manner. However, any comment or any, what from the party who requires the interpreter should also be conveyed in the same extent so that the message does get across to the court. there's something missing, the understanding isn't there. But it is not the court interpreter's responsibility per se to do that.
So for maybe Belkis, Hannah, and Amy, how can or maybe how should language access policies account for diversity in cultural and educational experiences in different communities?
I mean, I think that's a little bit harder for me to answer because I would say that they're not doing some of the basic things that they need to do to ensure that people are actually getting any interpreter services. And you had said not responding to sign language interpretation. Yeah, I mean, just because we talked about it earlier, I think it's worth raising that, I was talking about HRA, that HRA is one of the agencies that really, they just have so much to do, and they have a lot. I mean, it's a complicated need. It's more complex, but just to give an example, the Legal Aid Society has a case called Lovely H where we challenged HRA's failure to provide reasonable accommodations for people with disabilities at HRA. So in representing that class, what we learned is that the way that HRA deals with hearing impaired and deaf people is just, I don't know, it just doesn't make any sense to me. Like if you have an appointment and you come into the center on that day, they just don't schedule an interpreter for you at all. They say, oh, we're glad you're here for your appointment. Now we'll schedule you an interpreter for tomorrow. So that, and so people absolutely have to come back. They either have to wait around all day for the interpreter to maybe show up, or they have to come back another day. I mean, so I would say that, that seems like a thing that they could do, is just schedule those interpreters to be there for those appointments that they've scheduled for people. And, provide language line when it's available, provide notices in languages that people, people can actually read their notices. But if it's harder for me to say beyond that, what more they can be doing, I think there's a lot more that can be done.
I mean, this is really, really important in the work that domestic violence advocates do. But we're lucky in the fact that the people that are working at the centers, for example, but a lot of those people are the people who work in the advocacy community generally do a lot of training together and do a lot of work on how to best serve the needs of victims. And so I think the fact that a lot of the services are actually provided in the language, because we have multilingual staff, helps a lot in that regard in terms of assessing somebody's ability to understand what's going on. But again, because of this cross-training where it's not just lawyers who are working there, it's people who, they've gone through years of experience. A lot of them have MSWs too, so they're sort of really well equipped in terms of the language that they're using. And in general, our training takes into account the need for basic language and the assessment piece, which is, I think, important. And in terms of deaf clients, again, working closely with folks like the people at All Hands in Motion. So there's an assessment initially to make sure that this person needs an ASL interpreter. Even that basic question, or a deaf certified interpreter, is really important. It comes up sometimes even with, maybe it's the wrong language. Maybe the person identified as a Spanish speaker, maybe they speak an indigenous language that nobody identified. So sort of just preparing frontline staff, the people who are initially interacting with people, to make sure that that's being identified as early as possible is important and challenging. Don't get me wrong, it doesn't always go right, but sort of having everybody be aware of that, or trying to at least, is important.
Amy?
So I think one piece that hasn't been touched on by other panelists is that so applying for government benefits is really, really complicated for people who speak English. The applications are really complicated and ask questions that are not always clear. The procedures, what appointments you need to go to, what you need to do to reschedule, all of these steps are really complicated. So for someone who doesn't speak English to have the multiple barriers of this complicated process, and then on top of that language, it just makes compliance and the ability to access all of these services so many times more difficult. So I think one of the challenges for city agencies generally moving beyond language access is to really think about presenting information to the public in what's called plain English. So really kind of simplifying some of the public resources around how to apply for benefits, how to schedule appointments, how to maintain your benefits, all of these issues at every agency. So because all of that could be so much simpler, and that would benefit everyone, even English speakers.
So, and thank you for that recommendation. And I think in that spirit, before we turn to our audience for some Q&A, I'd like to give our panelists an opportunity to make one recommendation for moving forward. Amber has already talked about ways in which the Office of the Public Advocate can be a resource for individuals and advocates within the community who experience failures in language access at agencies. Going down, starting with Sandra and going down, can you help us to close looking forward? What, if you could recommend one thing to improve that language access, would you recommend?
Within the courts?
Sure.
Improve language access
Sure.
in the courts? Well, one of our challenges is we can always use more interpreters. Recruitment, as I think one of my co-panelists here said, is really critical and it's ongoing. We have a very significant high failure rate of our court interpreting exam because, as you know, the language spoken in the courts runs the gamut from slang all the way to the most erudite or technical legal terminology. And I don't think there's enough information out there to inform the public and interested people, linguists, how to prepare for the exam, the level of proficiency that is required in English and in the foreign language. And I think that if we could spread the word that it requires a person to be more than just bilingual or a native speaker, maybe involve the academic community. I don't know whether, I don't think it's being taught enough in area colleges and universities to the level that we require in the courts. I think that we would be better off. Thankfully, through the technology that we have in place, we're able to provide interpreters remotely within the court system, primarily from the metropolitan area to central and upstate New York. But it's not the goal. The goal is always to have a live interpreter, in the courtroom, accessible for private conversations, and to have that kind of flexibility. And so, if we could attract more qualified individuals and spread the word of what the level of proficiency that it is that we need, and help people prepare better, we would get more interpreters in a variety of languages. I know they're out there, but I get the sense that folks don't really prepare enough when they come to take our test. And we can always use more help.
Okay, I'm going to take two recommendations because I want to echo what Amy said about notices. I think that those can be improved, and I think they can be improved pretty simply. Again, speaking about HRA, the notices that people receive, the city-generated notices, are often manual notices in which it'll say, maybe in Spanish, the form language will say your benefits have been cut, and then the handwritten, always in English, says why. Like that can be fixed, right? Like, I think that's fair. But if I were to dream big about what I think needs to happen, I think it's a significant cultural change in which the attitude is how can I help you in your time of need? What can I do to assist you, as opposed to what can I do to make this harder for you? And unfortunately, I think that's often the experience of people. So I think that shift needs to happen.
Sure. So this is a bit of a difficult one since, there's a lot of attention on city agencies, rightly so, and I do work for the mayor. So I guess a recommendation for myself is to really be thinking through, and we are, how we can better conduct oversight and monitoring and really find a way to support agencies by providing deeper technical assistance and more resources. This stuff takes people at the end of the day to take this seriously, think through the policies, make sure they're hitting all the nooks and crannies of agency operations, and implement the policies on the ground. It really takes people and resources. So that's something we are taking seriously. A recommendation for this group, and really an invitation, is we want to hear from you. We do our job at the mayor's office in a much deeper, more meaningful way if we really understand the issues. And I echo the public advocate's invitation on that front as well. If you are facing issues at the agencies, and if you're not making progress in working with whatever channels you have developed at the agencies, come to us. We have relationships with all of the agencies and can help navigate some of those issues, and it helps us do our work in terms of our oversight if we're hearing direct feedback from you.
So I guess I'd start by saying that the positive side of things is that we are seeing a lot of people come into the Family Justice Centers citywide, and that the people who are coming, a lot of them, I think I looked it up today, it's like 46%, 47% are reporting that English is not their primary language. So that's a good thing. But of course, all of the people who do this work every day know that that represents the fact that there are so many people who are not coming forward. And there's still so much work to do in terms of even just getting the word out and getting the message out there in all languages, in all communities, that help is available, because it actually is. So we need to make sure people know that. I guess I would say, sort of thinking creatively in our world of providing services to domestic violence survivors, in terms of coordination across agencies, across systems in general. We're trying to work closely with the courts and the folks who are interacting with survivors who are in family court or in the integrated domestic violence court, so that we can, work even more closely when it's somebody who we think would probably be particularly intimidated to come to our office at 80 Center Street, and maybe providing one of our staff that speak their language and having them actually bring them to our centers, just as an example. So I guess I would just say, sort of thinking creatively, and that's my recommendation to myself as well, like you said, Kavita. And I would just echo what everybody else said too, in terms of hearing from everybody about when there's problems and if it's working or if it's not working, which I know a lot of people do, but just, it's true that you can't fix what you don't know is wrong. So.
Amber, I assume you also will be getting a flood of calls tomorrow.
Yeah, we are expecting it. We are very much looking forward to that. In partnership, this is not, again, to, everyone has a job that they have to do, but we all can do our jobs better in the interest of making sure that people are best served. And just to echo what Belkis had mentioned in terms of the cultural competency, my colleagues that are here, Shimtoli and Morgan in the back, we were talking earlier about the importance of cultural competency when it comes to city agencies. And just the respect factor that's there, people need to know that because someone may speak a language other than English does not mean that they are illiterate or that they are ignorant or anything like that. And I think changing that is tantamount, and that's something that we should all work to encourage. And then also, even looking at our office, city budgets, budgets need to reflect those priorities when it comes to making sure that city agencies have enough money in their translation budget, enough money to be able to provide the training that's needed to do those things is of critical importance. And when we look to making sure that we are inclusive of all communities, we have to think about how we're looking at documents. A simple fix, we're on the city website, and we tend to put everything in PDFs. Well, if you're a person, with, a hearing impairment and you're using a screen reader to get the information, well, the PDF doesn't work. You're not going to be able to get that information. And so we're spending all this money, translating documents and doing these things, but if they're not going to be able to be best served by those people that need them, then we're making serious mistakes. So those are the things that we want to look forward to working together as an administration to be able to accomplish those things. And again, I go back to budget. Those budgets have to reflect those agencies' priorities. And if there isn't money to be able to do that, look for other resources to do that in terms of training other city employees to be able to fill that void. But the budget needs to reflect those types of priorities.
Thanks. So I think Executive Order 120 was a huge achievement. And as Kavita mentioned earlier, every city agency now has a language access policy, which is extremely important. So I think my recommendation for this administration would be to really sort of kick it to the next level, so to speak, and ensure that these written policies become a reality for people on the ground. So really looking at implementation and thinking about how to make sure that employees on the front line, so whether it's a police officer or an HRA worker or someone at NYCHA or any other city agency, is appropriately trained and supervised to be sure that these individuals are providing the services that are required. The training and supervision are really, really important pieces to making sure that agencies provide these services. And then, and I know Kavita mentioned this too, which is fantastic, but oversight and monitoring. So implementing systems to look at how many limited English proficient individuals are coming to the agency and what's happening to them. Are they being provided with an interpreter? And if so, how is that documented? And it's really not rocket science, and it seems like city agencies are really lagging behind in having systems set up to be able to ensure that people who come in contact with them are tracked as a limited English proficient individual, which means that when they're sent a notice, it's sent in their language. When they are interacting with the agency, they're provided with an interpreter, and they're able to access these services. So tracking and monitoring, and then implementing a really meaningful complaint system so that people who are denied these services are able to go to the agency and file a complaint. And these complaints are very important for the monitoring of the agency, because they will put the agency on notice that services are not being provided. So those would be my recommendations.
So thank you to our panelists. And I want to turn to our audience and first stay on this theme of complaints, because I know we have a representative from HRA here. Is it Grace or Anne? Grace, can you please just introduce yourself and maybe talk a little bit about the complaint process that is available?
Absolutely. So my name is Grace. I'm the Deputy Commissioner for the Office of Community Affairs and Immigrant Services. In my portfolio, I have the Office of Refugee and Immigrant Affairs, and Montesano, who is with me, is the Executive Director of that office. Sharon Works is also with me, the Director in that office. And just to clarify a couple of things that were said by the panelists before I begin with our complaint process, we do have systems that track language. That system is a state system. And unfortunately, Amber, you're absolutely right. We need resources to make the information that we have work for the clients that we serve. And a lot of social services agencies have suffered from lack of resources for too many years, which makes this work even more challenging. On the notices issue, there are city notices that are translated based on the information that we capture in WMS. Unfortunately, the state notices, which are not translated, are the ones that usually have some kind of impact on your case, which makes it also incredibly difficult. So if I could have my wish list out there, it would be if all of you can help us with the governor's executive order on language access to make sure that HRA and other social services agency can do their job to the best of their ability, just on a database perspective. I agree that there should be some kind of like cultural change at the agency. As you all know, today we had our new commissioner start, Steve Banks. We're very excited about that, and it changes the cultural changes that would bring to HRA, making our job, I think, a little bit easier with our colleagues. But also, and there was one other issue that was brought up on HRA, but when I remember it, I will get there. On the complaint system, 311 was set up to be this repository where it was easy for all of us to go in there, me included, if I have a parking issue or whatever, to get to 311, file my complaint, and then they will get it to the agencies. That's honestly the easiest and quickest way to get it to HRA or any other agency in the city. We also work with the Mayor's Department of Operations, who's making sure that we're responding to these things within 14 days, unless there's an emergency. Beyond that, HRA, it's also in my portfolio, is the agency's call center, info line. We have some information here. We can put it outside for everyone. You can call there and file a complaint. You can also, and you may want to give your hands up to this, send us an email at constituentaffairs@hra.gov. So we will hear about very broad general complaints. Well, this center is terrible for these reasons. That's not enough for us to investigate. And when I met with advocates, I told them about the work that we do and the partnership that we're looking forward to with them so that we can do our jobs better. Usually the response that I get is, you know what, I don't think my client is going to be comfortable giving us specifics. So my second wish list is encourage your clients to give specific information so that we can do our jobs better. We honestly do consider ourselves an advocate within the agency on these issues. We don't do this work for the money, we do it because we really care about language access and making sure that immigrants are getting access to our benefits. We can't do that with a real meaningful partnership with all of you and the other advocates that are not here. We're hoping that what happens with Steve Banks is that those doors are open and that we're able to have those conversations. The last thing that I would write down, if I were you, is the phone number that you can also call, which leads directly into the people in my office who are doing this research all the time. That's 212-331-4640. If your client is having an issue with HRA and it's imminent, call that number. We will help you. If that's not happening, email me personally. I will make sure it happens. So I'm happy to answer any questions that anyone may have.
Thank you. So I think Grace will stay around after and give her number and cards and emails to others, but I just want to call on others who have questions in our remaining time. Yes, sir.
I'm former head of the Mayor's Office for People with Disabilities. I think it's important that people understand that people who are deaf, people who have other communication disabilities, either sight or cognitive, etc., are not covered by Executive Order 120 at all. We are covered by the effective communication provisions of Title II of the Americans with Disabilities Act, so that when we're looking for stuff, have to look. Section 504 of the Rehab Act of 73, and also the City Human Rights Law, 8-107 subdivision 4. So look there if you are looking for how to, or what you're required to do, because the requirements under those laws are much stronger and much broader than Executive Order 120. If anyone has questions, I'm ready.
Thank you. Other questions? Yes.
Hi, I just wanted to introduce myself. My name is Colleen Duffy. I work for ACS, the Administration for Children's Services, as the Language Access Coordinator. Very pleased to be part of the audience tonight and appreciate everyone's contributions. I wanted to let you know that there's a way to contact ACS if your clients are having language access issues, and that's by contacting our Office of Advocacy, and advocates are also welcome to contact me directly. So for members of the public, the Office of Advocacy is the best place to go, and I'd be happy to read off the phone number.
I think
Or
people
you
can come
see
up.
me at the end,
Sure.
or also please reach out to me if you would like to continue the conversation with ACS beyond tonight. Thank you.
Any other questions? Yes, sir.
Yeah, so I understand the purposes of actionability. It's important to deal with language access as a discrete issue, but I was wondering if the panelists could talk about, like anecdotally, how language access is maybe in some cases racialized, gendered, so like are deaf people of color, do they have a harder time getting the services that they need as opposed to, you know, if anyone could speak on that, I'd be, and also are there statistics about those issues?
So I don't know if there are statistics. I would just be willing to bet that people of color with disabilities and language access difficulty are going to have a harder time. But I don't know who tracks those statistics. But
Yeah, I would just add to that yeah, I agree. I also don't have statistics, but I know that limited English proficiency is very correlated with poverty, and of course poverty is very correlated with race, and so you see higher percentage of limited English proficient individuals in low-income communities, and also higher percentages of people of color. I'm not a statistician, but and I would say most of our clients who are limited English proficient and report barriers with agencies have other barriers as well. So they're people with disabilities, or they're women who have experienced gender discrimination. The case I was talking about with regard to the NYPD, all of our plaintiffs in that case pretty much are people who are victims of violence, have immigrated here. Many have immigration issues, language barriers, have been treated in completely inhumane ways by the police, which not only is reflects language issues, but gender and race and violence issues as well. So I think the barriers are often multiple barriers.
It's my experience, it doesn't happen very often in the courts, but we have had cases in which a person appears in the court who is not originally English speaking. For Spanish speaking, we've had at least 2 instances where the person has lost their hearing as an adult and does not know American Sign Language, obviously, and doesn't know how to read lips. And we have found a way, we do what we can to make sure the person understands. And in these 2 instances, one was a grandmother in the Bronx family court who wanted custody, and she could read, thankfully, she could read Spanish. And we had 2 interpreters, one orally interpreting what the judge was saying in English and another one acting as a transcriber, so to speak. And the oral interpreter, who was actually repeating it in Spanish, was doing one job, and then the second interpreter was actually typing in a very large screen the Spanish so it could be read by the grandmother. What we would have done if the grandmother was not literate, I don't know. That didn't occur. And another instance in which someone was suing for a large amount of money, a man who worked in a garage, a mechanic, Spanish speaking his whole life. There was an explosion in the garage, and he lost his hearing. He needed to testify. He didn't know sign, he didn't know lips, he didn't know anything. And thankfully, we were able to provide service that way.
Yeah, this doesn't necessarily address the issue of race, but just that this reminds me of that, is that for the hearing impaired at HRA centers, often what ends up happening is they provide handwritten notes to say, come back at this time. But there are, if you're illiterate, then that handwritten note means nothing to you. So that, again, like talking about the compounding of problems and of issues.
Just add one other component. If you look at your problem agencies, you'll probably find some correlations with those discriminatory practices. You mentioned NYPD as one of those areas. So I'd be curious to see if you do come across that data set. That we'd love to take a look at that. I think everybody would appreciate being able to become more knowledgeable about that.
I wasn't expecting to talk about this issue, but I'm really glad you brought it up because I do think a bit of a mistake we've made and I mean we as a big giant we in the world of language access is that it has become really siloed. So I think at the beginning, Amy talked about language access as being actually about equal access to certain rights or services. And I think we've left language access as this standalone issue when really, I think as you're alluding, it really is, the intersections with race are huge. The intersections with immigrant status are huge. And when we're really doing, I think, a disservice when we do separate the issues. And I think, this is a very government way of talking about this, but I'll put it out there. I think the work we have to do on language access isn't just about language and interpretation and language line and translation. It is about shifting cultures, I think Belkis talked about, and partially perhaps through cultural competence training, where we're really looking deeply at what is it that's going on for frontline workers who we can't pretend that we're in some kind of post-racial society where there still are very real tensions between new immigrants and old immigrants, African Americans and immigrants, new African Americans and Africans from the newer immigrants from the continent. The list goes on and on and on. And without attacking or looking at that broader context, those biases that are running right underneath the surface and sometimes above the surface for folks, it is, I think, very difficult to in a kind of holistic manner look at this question of language access. So I think the call I put out here is for us all to be making those intersections in the conversations that we're having, and to not treat this as a standalone issue. So I thank you for bringing that up.
So I think this is a great place to end our discussion, although we could go on for many hours. I want to thank all of our panelists for having a wonderful discussion. To obviously the public advocate, I see that she's left, but people in her office, thank you so much for being here, and I hope that you will all continue the discussion informally as we wrap up now. Thank you.